Well, we can start the second session, and more oriented toward the practice, protection, migrants and mass migrations. And the first speakers is Ioannis Papageorgiou, Associate Professor at the Department of Political Science at the Aristotle University of Thessaloniki, Greece, and Ioannis teaches European integration, European political system and comparative politics. He's a lawyer, but he has also a master in political science. His academic research is basically focused on the European political integration, immigration policy, and international humanitarian and refugees law. His presentation is on refugees protection, political asylum, and economic migration. I lost my here we are overcoming the refugees crisis debate, a single European refugees status. Please, the floor is yours.
How does this work?
I have to turn off.
Okay, thank you. Thank you, and apologies for my voice. I got a hay fever since yesterday, and I'm a little bit tough in the voice, not in the content. I'm going to give some hints of the work we're working on currently in the university, which is a method of applying practically supranational solutions to current national and regional problems, more specifically the refugee issues in Europe. I mean, I'm coming from a country which has seen, and I'm talking in a country which is seeing as well, a significant amount of distress and a significant amount of upheaval due to the recent refugee crisis, a crisis which reached the peak in 2015, in Greece at least, is continually on the increase in Italy currently, and shows possibilities of a reappearance in Greece again nowadays. The objective of the research and the objective of my intervention is how to deal with a national problem with in a European perspective, trying to give another context whereby issues will be much less tense and much less divisive than at national level. I will start with some early observations which to some extent have been shared by the speakers in the previous panel. The refugees in Europe are a sort of island of national competence and island of limited movement in a sea of free movement. The European Union has developed since the 60s and perfectioned a system of free movement for all its citizens. Gradually, since the 90s, it has established a relatively open system for the movement of legal migrants within the European Union, not a complete one and with various limitations, but there is a possibility for free movement of migrants who have developed, who have received what we usually call long-term resident status. This is not the case with refugees. For historical reasons, asylum seekers and refugees were dealt as a separate group of persons in mostly, or in all member states practically. And when the European Union started dealing with asylum and migration incompletely and partly, refugees continued to remain under the absolute national sovereignty. I talk about persons who apply for asylum as well as recognized refugees who received a status. What I mean is that recognition of refugees, in international refugee law, the refugee status is a relationship between an individual and the state. For historical reasons, the recognition of a refugee was not or should not have been a hostile behavior vis-à-vis the state of origin, and for this reason it was a very much bilateral relationship between a state and an individual. This was all fine and correct till when Europe started having a significant number of refugees. I remind you that persons who are, the applications for asylum in Europe remained at a very low level till the early 90s. Very few people applied for asylum. Most people arrived in Europe under a form of organized organized migration status. Few people arrived as refugees. In the 1990s, asylum became a significant entry characteristic for third country nationals in Europe, to a large extent because legal paths to migration were reduced. But although Europe started in the 1990s to establish a number of common standards, in the beginning there were minimum standards, and later on common standards who had to do with the examination of an asylum application, the reception conditions of persons who apply for asylum, even some basic rights of individuals who are recognized as refugees. A refugee recognition, what we call a refugee determination procedure, remained exclusively national. At the same time, Europe witnessed what one could call, what we call secondary movements, so movements from one to another member state of persons who were asylum seekers or who were even recognized refugees, in a situation of total irregularity. Refugees were not allowed, are still not allowed to move. Now they can move in order to visit other EU member states once they are recognized as refugees, but the relationship between a refugee and a state was exclusive and still remains to a large extent exclusive. For many reasons, this was due to the novel situation of Europe. It was a continent without borders, and as a result, movement was easy. It was extremely difficult to control interstate. It is very difficult to control interstate movement unless you base yourself on features of one person, which is violating human rights and discriminate. As a result, EU member states tried to establish other forms of controlling refugees and asylum seekers. And at the same time, one important aspect which came to the forefront was, to a large extent, due to the fact that asylum became an issue in the context of a wider mixed migration movement, where you had people who were moving to better conditions because they were fleeing danger, and at the same time they were trying to settle again in a new country. And I remind you that the Geneva Convention, 1951 Geneva Convention, includes among the rights of refugees the right to integrate, and the right to integrate can be interpreted in many ways, including the right to seek a decent job, to bring your family, to establish permanently in a country. All this led to a questioning of what exactly asylum as a right includes, is it a right to protect yourself directly from persecution, or is it a right to sort of select the country where you would seek protection? As I told you, the EU member states started from the 1990s to discuss migration, also in the context of migration and asylum, mostly migration, to a lesser extent asylum, although the legislative production of the European Union was more significant in the area of asylum because it was easier to establish legal text than in the area of migration. Since 2000, Europe set a common European asylum system. It was, as I told you in the beginning, mostly minimum standards, later on common standards, but these standards referred to the situation once a refugee is in the country. Entry remains a national competence. Control of entry remains a national competence. The European Coast Guard and Frontex, which have been established, have a role of assistance and support rather than direct control. And the Treaty of Lisbon, clearly states that the number of migrants, of persons who can enter a member state, are exclusively settled by the specific member state. So we see a system of, how I would call it, a binary approach to third country nationals. As long as they are outside, they remain under the exclusive national competence. Once they're inside, member states have to follow a number of common rules vis-à-vis them. It can be called hypocritical, or it can be called a compromise agreement, in the sense that Europe has not reached the level of a federal state yet. No, sorry. How does it move? Okay, I don't know how many of you are aware of the intricacies of the common European asylum system. I think most of the Italians know the concept of the Dublin mechanism. It is too complicated to explain. If you know it, you know it. If you don't know it, tough luck. But in any case, the system of the Dublin mechanism means that one member state is responsible to examine an asylum application. There is a hierarchy of criteria which are used in order to determine which state is responsible. It has to do with the state. The concept, which is interesting when we talk about refugee issues, is the responsibility falls on the state which is more responsible for the presence of an individual in the EU. So one can be more responsible because there's another family member of that person already in the EU. Or a member state can be more responsible because it issued a visa or it issued a residence permit. If you go on in the hierarchy of the criteria of the Dublin system, you see very much in the bottom one condition, which is the state which is responsible for the first entry into the EU of the asylum applicant. In the beginning of the Dublin system, the entry was a very flexible concept because a lot of asylum seekers came by plane. Many people came from the external borders, but other people overstayed their presence in Europe. So it was a criterion that was not particularly used. Other criteria were more practical. Since the mid-2000s, most European states increased the control of regular entry by plane mostly. And as a result, as well as a result of the increasing tensions outside Europe in the southern and southeastern part of the Mediterranean. The majority of asylum seekers came to Greece, to Europe, through the south, and in 2015 through Greece. Earlier through Italy, I would say, and even earlier most came through Spain, but since 2010 the majority of entries into Europe were from southern Italy, from Libya to Malta, and from Turkey to Greece. The crisis of 2015 was a significant, brought a significant number of persons to Europe. About 1,400,000 applied for asylum in 2015, mostly but not all Syrians, and led to the collapse of the Common European Asylum System in principle, because it led to the collapse of the Dublin mechanism. Persons crossed into Greece without being fingerprinted, without being registered, and continued their way to Germany, mostly Sweden and Austria to a lesser extent. Rules did not apply, which is an interesting approach to explain why we have to change rules when they don't apply, because the context changes. And we witnessed an increasing reaction among member states. Firstly, a nationalist reaction. It's not our problem, so we close our borders and we try to bypass, to have the current of refugees bypass our state, or we open our borders very much and try to push refugees to the next state, hoping that nothing tragic will happen on the way. This increased, I think it was also discussed in the previous panel, this increased significantly the conception of migration as a national security issue. There is a long discussion since the 80s about what one calls the securitization of migration. Migration is considered from the security aspect mostly, and led to the collapse of the European Common Asylum System. Our proposal, which has to be presented in 3 minutes, is a proposal whereby we use the European context, the European institutional context, to establish to reach a European solution to a national issue. Refugee issues have a significant political and a significant financial cost. Most of this cost is national. Integration, reception, and administration. Europe tried to deal with that, firstly with harsh measures internally, and secondly by trying to establish a sort of cordon sanitaire, a sort of safety belt around it. The most explicit such safety belt was the concept of safe third countries, countries where applicants could remain without necessarily reaching the EU. The proposal and the idea that underpins this suggestion is to provide an integrated system for asylum seekers and an integrated system for establishment of refugees in the EU. The Commission made the communication in 2016 which presented various options on how to improve the common European asylum system, and it also, the Commission always gives a sort of fifth option or sixth option or third option which immediately is referred to the domain of the long-term, meaning imaginary, or let's say we give you that approach but nobody wants that. The third approach which we work on is a single European asylum status, not a common one but a single status, which includes centralized decision-making, a complete harmonization of the procedures, and consistent evaluation of the protection needs at EU level. It includes a European process with the same procedures and a similar assessment. In that context, having the Dublin system whereby one member state is responsible is no longer necessary, because there is a single status, so whichever member state is responsible, the status remain identical, and provide the same rights for all refugees. We are now working, what basically we're doing is to work on the legal and constitutional implications of this, because for many member states, refugee adjudication has to be made through civil servants, and therefore we have to see how this can be done at a technical level. There are examples. I mean, the United States is the most practical example. It is a different case, but the United States has the possibility to, most United States refugees are refugees from resettlement, which means refugees who have been recognized as refugees somewhere else and they are resettled in the United States. They are obliged to reside in one state for at least some period of time, otherwise they lose benefits, education or training. So there are possibilities whereby refugees will not all flock to Germany, which is the basic underlying. And the same happens also within Germany. Germany has a system of distribution of asylum seekers at a land level. And the last issue, it is a way to increase the European budget without increasing the contribution of the state. As I said earlier, the amount of money member states spend on on asylum seekers and refugee issues currently is significant, and it is national. The same amount could be widely used at European level, be part of an EU budget. We're discussing now the MFF, and provide an increased European added value in a totally European problem. I'm sorry if I have overgone my time. Thank you very much for your attention.
Thank you. Thank you so much for your presentation. It shows in a very clear way the paradox of the refugees' condition. The common European asylum system obliges Europe and its member states to protect and offer safe passage for people fleeing their country to escape war and persecution. But on the one hand, Europe declared itself not able to receive all the refugees. And on the other hand, the recognition of the refugee status is a national affair. This is clear heritage of the 19th century refugees debate. Well, the second speaker is Alina Svabo. Alina Svabo teaches international public law and criminal procedure law at George Bacovia University of Bacău in Romania, and holds a degree in law and another one in philosophy, so lawyer and philosopher. Well, presentation is about national security as a ground to refuse asylum and refugee protection, the Romanian experience. Please, Alina.
Thank you very much.
I have to come up.
Okay. Thank you very much. I started this presentation by doing some research on European asylum and refugee law. Then I moved to Romanian law concerning migration policy and refugee protection in general, and then I moved to a national security as a ground to refuse asylum in particular. After that, after this theoretical research, I tried to look into the jurisprudence. I looked into the European Court of Human Rights cases concerning Romanian situations, and then I tried to see that after this kind of cases, the Romanian judiciary understood something from those convictions at the European Court of Human Rights, and I tried to see if something has changed. So I presented some Romanian cases which are more recent. Of course, at the end, I tried to reach some conclusions. I won't get into details about the European law concerning refugee and migration. I just put it down as an introductory to my presentation. I will get into details in the written paper that I understood that might be published after the conference. Going to the Romanian law, I must say that, of course, as a European member of the European Union, the member state, Romania has implemented the legislation in the matter. We have a law on asylum. We have, for the purpose of this presentation, I looked into the Romanian law on terrorism and also Romanian law concerning the aliens regime, but also the access to public information. Of course, I believe in the whole member states the situation is the same. Romania recognizes the refugee status, the subsidiary protection, also temporary protection. The procedure to get this kind of protection is an administrative one, followed or not by a judicial one. It usually is a regular procedure, but also sometimes it goes by the accelerated procedure. And the accelerated procedure to get the protection is when the person who is looking for the protection come from a safe country, or those whose applications are manifestly unfounded, but also they get into an accelerated procedure when the Romanian authorities consider them as a threat to national security. The law on asylum foresees for the protection procedure, but also it provides for the reasons that could be taken into account to exclude those who already got the protection. So if we analyze the three forms of protections, in the case of the three forms of protection, national security is a ground to refuse the protection. We see that in case of temporary protection, the person must be convicted for a very serious crime. Or in the case of subsidiarity protection, the person does not really have to be convicted for a crime, but it's enough if the authorities consider them as a danger to national security or public order. The exclusion from refugee status is larger. a person cannot be granted a refugee protection if there are reasons to believe that he might have been committed a serious crime. So it's not sure that the person has committed any crime, but if there are reasons to believe. And the categories of crimes is larger than in the case of temporary protection. The law on terrorism provides some situations where if the protection was offered, that protection can be annulled or cancelled. And this is when the authorities declare that person as a persona non grata, undesirable person. Also, as in the case of granting the protection, it is an administrative procedure, and which is followed or not by a judicial one, depending if the person attacks the decision in court. A person is declared a persona non grata if there are reasons to believe that he or she is involved in activities which are a danger to national security. The request is made by the public prosecutor near the Court of Appeal in Bucharest. A decision is taken in maximum 10 days. It is a closed session and mainly is based on classified documents. Of course, there is the possibility to appeal the decision at the High Court of Cassation and Justice, but it has no suspensive effects, meaning that in case a person is declared persona non grata, he or she will be returned in the country of origin immediately. There are some exceptions, especially provided by the law, just to avoid some prejudices. And the trial takes place in urgent procedure. I tried to look, I was curious to see if there were any cases at the European Court of Human Rights concerning refugee law, and unfortunately I found a couple. The first one I took into account was a decision from 2006, which concerned Mr. Lupșa, where the court founded that Romania violated Article 8, which is the article to family and privacy. Shortly, just to give you an idea, Mr. Lupșa was a Yugoslavian citizen. He came in Romania right after the Romanian Revolution in 1989. He set up a company, he had a family, he had a daughter. He moved around back and forth from Romania to Yugoslavia. He had no problems with that. But once in 2003, after returning from his home country, he had no problems at the border, but after he reached the apartment where he lived in Romania, the police came and took him, telling him that actually he was previously declared a persona non grata, of which he didn't know. So actually he was returned in the same day. His lawyer made a complaint in the judicial court. He found out, as I told you, that he had been declared persona non grata based on secret documents that he had no access to. And the European Court of Human Rights found that this was a violation of Article 8. because actually he was not served with the order of declaring his presence undesirable on the Romanian territory until he was already deported. So this was from 2006. I had some other cases from 2011 and a recent one from 2015. So the same pattern happened. And after the European Court of Human Rights found violations, I try to see if something has changed into Romanian jurisprudence, if Romania have learned something from that experience. And unfortunately, I realized that this is not the case. In the present days, the situation is the same. The procedure concerning the declaration of a persona non grata is very accelerated from one day to another. It takes place in a closed session based on secret, unclassified information that the person has no access to. And the trial is set up from one day to another. Just to give you at least one example, in 2016, so after the convictions in the European Court of Human Rights, one case where the prosecutor was asked by the secret services to lodge request to the Court of Appeal in Bucharest to declare SA as a persona non grata because they had information that he has been involved in he was supporting some extremist organization from home region. The trial was set up for the next day. He was present, he had no lawyer but just an interpreter. He requested a lawyer, his request was denied. The court pronounced him a persona non grata in the same day, so he was declared undesirable for the next 10 years. And the next cases that I found from 2016, 2017, actually they follow the same pattern. From one day to another, the person is declared persona non grata based on reasons to believe that those persons are involved in terrorist activities. Okay, and I try to see if this is legal and this is normal. And yes, I found that the Romanian Constitution does provide for the right to information, and the European Convention on Human Rights does provide for the freedom of expression, which also includes the right to receive information. And the law on the access on public information also provides that yes, we do have access to public information, but still the right to information is not an absolute right, and the exceptions are also found in the same laws. So the Romanian Constitution provides that in case of national security, someone cannot have the access to the information. Also, the European Convention of Human Rights provides for some limits, and also the law on access to public information. If wanted, the lawyers can have access to some kind of information, but then they have to have a special authorization, which includes the verification of their person from all points of view, probably meaning that that person gets to be listened, followed, registered, I don't know what is the procedure, but eventually if that person proves that he is trusted, he can be trusted enough, he gets that kind of authorization. Just to finish, I found a very interesting article in our Criminal Procedure Code, which provides that in criminal cases, if the classified information is essential for a solution in that case, declassification of that information must be allowed, or at least access has to be allowed. Otherwise, no conviction or any solution establishing the defendant's guilt can be pronounced. Unfortunately, when it comes to the aliens regime, no such provision exists. So, in my opinion, there is no balance between the rights of the aliens and national security. The legge ferenda, it could be in the judicial proceeding, the legal representation might be free and also mandatory, and if that's okay, that only some categories of lawyers have to have the special authorization, then the legal representation could be granted from those kind of lawyers who might be chosen from a list. Thank you very much.
Well, thank you, Alina, for your recognition of the Romanian refugee law, and we can go to the second plan intervention of Anna Germano and Valeria Tevere, both from the University of Salerno. Anna Germano has a PhD in European area of freedom, security and justice, as an adjunct professor in European law at the Specialization School for Legal Profession at the University of Salerno, and Valeria Tevere is a lawyer and PhD student. She has to discuss her thesis, and he works on violence, gender violence. And well, their presentation is about homosexual asylum seekers within the European Union. Please, I don't know, you are organizer too.
The microphone doesn't work because yours is open.
No,
not yours.
Yeah.
Microphone. Okay.
Okay. Thank you. Ms. Valeria Tevere and I are very honored to be invited to speak to this international conference. First of all, we would like to congratulate Professor Susanna Cafaro and all organization for this important event. Well, I will start our short speech with a general overview on the asylum seekers who fear persecution in their country of origin on grounds of their sexual orientation. Later, Ms. Valeria Tevere will focus on homosexuality tests based on psychological evaluations. As is known today, many asylum seekers are fleeing persecution for reason of their sexual orientation in one of the 75 countries in the world where being gay is illegal. In this regard, we remember that the first subparagraph of Article 1 of the Geneva Convention, that constitute the cornerstone of the international legal regime for the protection for refugees, provide that the term refugees is to apply to any person who, for the fear of being persecuted because of race, religion, nationality, political opinion, or membership of a particular social group, for example on the ground they are homosexual, is outside the country of his nationality. That question gives rise to difficult and delicate issues concerning, on the other hand, the rights of individuals, such as personal identity and fundamental rights, and on the other hand, the position of the member state of the European Union when applying measure of minimum harmonization, namely the Qualification Directive and the Procedure Directive. In the gathering and assessment of evidence relating to application for refugee status. In addressing those issues, further questions arise. For example, must member states accept an applicant's several sexual orientation? No. Whether an applicant established that is homosexual cannot automatically obtain refugee status within a member state. No distinction is made between the various grounds of persecution. Member states must assess all applications for international protection. It follows that applicants who claim refugee status on the ground that they are homosexual are not exempt from the assessment process. Therefore, how should that process be conducted in a manner that is consistent with fundamental rights? In this context, an individual's sexual orientation is a complex matter, entwined inseparably with his identity that falls within the private sphere of his life. In this regard, neither the Procedure Directive nor the Geneva Convention, the Charter of Fundamental Rights of the European Union, lays down specific rules how to assess the credibility of an applicant who requests refugee status of any ground, including that he belongs to a particular social group because of his homosexual orientation. That assessment does fall within the ambit of national rules. There is no doubt that an applicant's definition of his own sexual orientation plays an important role within the assessment process of application for refugee status. Such declarations should at very least form the starting point of the assessment process. For example, the United Nations High Commissioner for Refugees has divided the various methods of assessing credibility under discussion into two categories. Some which are in all circumstances contrary to the Charter of Fundamental Rights, it describes as comprising a blacklist. They cover invasive questions concerning the details of an applicant's sexual practices, medical examinations, and abusive requirements relating to evidence, such as asking applicants to provide photographs of themselves performing sexual acts. The second category is described as a grey list. It concerns practice which, if not applied in appropriate or sensitive manner, risk being contrary to the Charter. The grey list includes practices such as concluding that an applicant lacks credibility because he fails to give a correct reply to general knowledge questions, for example, concerning organizations that represented homosexuals in the country where asylum is claimed. Anyway, in conducting the credibility assessment, the national authorities should not apply stereotypical notions to applicants' claims. Determination should be predicated on the assumption they are correct and incorrect responses to an examiner's questions. For example, that an applicant is not credible if he fails to display knowledge or political issues or particular activities that concern homosexuals. Such practices are inconsistent with Article 4 of the Qualification Directive, which requires the competent authorities to take account of the individual and personal circumstances of the applicants in question, in full respect of the fundamental rights, as also underlined by European Court of Justice. But on this point, I give the floor to Valeria Tiver. Thank you.
Thank you. No, doesn't. Okay. Thank you. As my colleague, Mrs. Anna Germano has just said, the process of assessment of requests of asylum made an applicant on grounds on his sexual orientation is a complex matter. We don't remember that these people are vulnerable person. Because of there is a strong intersection between different factors, for example, race, sex, religion. So they suffer this multiple discrimination. In this regard, we don't exclude the use of expert reports, but there are limitations in this use, and in particular, these reports must respect the fundamental rights, the right to private life and the dignity, human dignity. So recently, I'm focalizing on a specific case of the Court of Justice of the European Union, and in particular recently in this matter the third chamber of the Court of Justice of the European Union has decided in the case C-473/16 in the judgment decided in January of this year. The request has been made in proceedings between F, a Nigerian national, and the Office for Immigration and Citizenship of Hungary State, concerning the decision rejecting the asylum application submitted by F, and stating that there was no obstacle to his refoulement. And it must be noted that the applicant asked the international protection according to the Convention of Geneva relating to his sexual orientation. And in these proceedings, it was used an expert report based on psychological tests. And according to F, the applicant, this forensic report prejudiced his fundamental rights. So the court rules these principles. It's allowed to use the expert report to examine an asylum applicant according to Article 4 of Directive on Standards for the Qualification of Third Country National as beneficiaries of international protection relating to his sexual orientation, but it can be based on the psychological tests, which are disproportionate to the aim pursued and interfere with the person's right to respect for his private life. And the court also refers to the Article 52 of the Charter of the Fundamental Rights of the European Union, and according to this rule, limitation may be imposed on the exercise of the rights and freedom recognized by the Charter only if they are necessary in observance to the principle of proportionality. And it's also necessary to take account in order to assess the seriousness of the interference arising from the use of a psychological report. And in particular, the court also refers to Yogyakarta principles, international principles, in relation to sexual orientation and gender identity. So, in conclusion, in the light of this judgment, the credibility of an asylum seeker relating to his sexual orientation must be based only on objective elements. For example, if there is a national legislation which criminalizes homosexuality and sexual orientation, unlike the credibility of an asylum applicant based on psychological test doesn't respect the fundamental rights and the human dignity. Thank you for your attention.
Thank you both. Well, please. Now, before opening the debate, we have unscheduled intervention of Irene Piccinini, who will inform us about interesting initiatives. We are welcoming Europe, but I invite Irene to give some information about you, about your initiatives. But please.
Thank you. And I would like to thank you, the organizing committee, and especially Professor Susanna Cafaro, for allowing me to explain this initiative, which is a European Citizens Initiative that is the most visible and legally binding tool for direct democracy in Europe. A European Citizens Initiative is a way for European citizens to let their voice heard by the European Commission. That is, by if 1 million European citizens from at least 7 European state members sign the petition within a year, the European Commission is obliged to hear the demands of the citizens in a formal procedure. And the initiative I'm presenting here is called Welcoming Europe. We are welcoming Europe because it's addressing some issues about refugees, asylum seekers and migrants in some aspects that as a European citizens we find that it is very questionable how some European state members deal within their legislation. There are 3 issues that are addressed in the petition. The first one is that solidarity offered to migrants and refugees and asylum seekers should be free. Like anybody shouldn't be convicted by their state because they offer solidarity. So distributing food, giving a lift, buying a train ticket, or rescuing a family from drowning shouldn't put people at risk to be fined or arrested, how it is now in half the European member states. So the people are called traffickers, and there's no clear distinction between trafficking, smuggling, and humanitarian assistance in some European countries. And it is a very recent cases in the borders between France and Italy. Some people were convicted because they helped pregnant women, bringing them to the hospitals. And so this should be changed, and we did, one of the issues is this one, solidarity. The other issue is to offer safety to people fleeing persecution. As European citizens, we are ashamed that people fleeing persecution must risk their lives to be safe on our shores. So European citizens want to save lives and provide legal and safe ways for those fleeing persecution, and they should be able to do so. So through community sponsorship programs, European citizens can act as sponsors so that those in need can arrive to Europe safely and become quickly and easily integrated in communities. So this second issue is to favor sponsorships, also private sponsorships, through a dedicated budget. So the European Union now does not have a budget or to enhance sponsorships, private sponsorships. That's the second issues that we address the European Commission. And the third issue is to offer justice to victims of exploitation and abuse. So we want a system that protects all people. That we heard some issues addressed, and it is sometimes very difficult to help people victims of abuse. Most non-European citizens are targets of trafficking crimes and human rights abuses, and they do not get justice or file complaints because they fear they will be deported by the authorities. So, but this should not be the case, and if the complaints mechanism under European law were effective. So we call the European Commission to listen to its citizens who want a working justice system for all and guarantee more effective ways and rules to defend victims of exploitation and human rights abuses. So this European Citizens Initiative has now organizing committees in several European countries, in Austria, Belgium, Bulgaria, Croatia, Estonia, Finland, France, Greece, Ireland, Luxembourg, the Netherlands, Portugal, Czech Republic, Slovakia, Slovenia, Spain, Hungary, and Italy. In Italy, it was launched just last week in the Senate with Senator Emma Bonino and Luigi Manconi and some other representatives of the very large network of organizations who are supporting this initiative. The European Citizens Initiative can be subscribed either online through the website. We are welcoming Europe.eu, or in Italian is welcomingeurope.it. We will be collecting signatures also on the road, so to speak. I think it is important to know that there are, like we heard Professor Ioannis Papageorgiou, how also changing is possible, and I think that this one initiative is a way to change. And so if you are interested to sign the petition or also maybe to collect signatures, this will help. We have 1 year time until next February 2019. Thank you very much.